Hello, if you're watching this video, it's because you want to understand more about the legal aspect of your business, especially with respect to trademarks, more than you want to know who I am. But I'd say let's start from the beginning. I'm Omolere Abisola, legal practitioner with more than half a decade experience in intellectual property law. In the course of my legal practice, I have worn many hats, from legal secretarial services to providing corporate legal services to legal representation as a counsel to now offering legal consulting in contract and IP, particularly trademarks and copyrights. Having consulted for several businesses and non-profits and contributing to their mission by safeguarding their intellectual property and managing relationships with their stakeholders, I've witnessed the transformative power of a well-protected trademark, not just as a badge, but as a shield and a legacy. Whether you're an entrepreneur, a startup, a nonprofit with a vision, creative, your brand deserves more than recognition. It deserves protection. And at the end of this video, you'd understand how your business and your work can benefit from trademarks. I used to think that a lot of people just didn't pay attention to trademarks with respect to their business, but over the course of interaction with clients, I get to see that they're not really aware of the impact of trademark and how their business can benefit from it. And this is one of the reasons that this video was put together. It was necessary to create this video to answer a lot of questions that clients usually have with respect to trademarks. Without further ado, let's get into this section. So what is a trademark? Think about a trademark as your brand's identity, like the DNA. It's that thing that distinguishes it from all the businesses in the same class of business. So let's take, for example, Oral-B, which you may be familiar with, and Close-Up, right? They're in the same industry of providing oral health, right? So how do you distinguish one from the other? If you'd said the name, well, you would be correct because a name is a part of their trademarks. So trademarks can be anything from name. It could be names. It could be images. It could be a combination of both. Just that thing that registers in the minds of your audience that this is you. So the features, if we looked at a human being, we're talking about the features, the way that I smile, the way that I talk, the way, and with respect to a human being, what makes one person different from the other person, their makeup. So it's a combination of everything that helps you distinguish them from your competitor or from any other business in the same class. The law requires that this mark, your mark, be distinctive. It should be different from any other thing that there is. Again, Oral-B, Close-Up. It could be a combination of words or visuals. It could be just words, as in Omolere Abisola Esquire. It could be just words, as in Mentos. Or it could be just logo, as in the famous Nike swoosh. It could be a combination of both of them, like Can't Turn the Word. Trademarks are protected under the Trademark Act, which is a law of the Federal Republic of Nigeria that then gives you exclusive rights to use that mark with respect to your business. And to exclusive in this context means that you can prevent other people from using a mark as similar to yours. And this is why one of the requirements of trademark is that it has to be distinctive, because it's that thing that is special you're trying to protect. There are different classes of trademarks. There are different classes under which you can register your trademarks. As of today, there are 45 classes, some of which are classes for goods and some of which are classes for services. And this is the way it works. If you offer a service, then you want to register your trademark in the class of that service. And if you are in the goods, maybe if you sell clothes, for example, that those are goods, and then you want to register under the class of that good. If you're a tech startup, for example, you want to register under class 42. Class 42 is what covers for services in the tech space. So you want to register under that class. And there are times when you want to register in multiple classes. It's possible that your business or your goods or your service fall under more than one class. And in that case, you want to consider registering in multiple classes, or for a start in the most relevant class to you. And again, this is where a trademark attorney can really help you decide the best class for you to register your goods or your services. Right. You could, and nothing stops you from registering in all 45 classes, but you can imagine that it's going to be more expensive. And sometimes you don't even need to, depending on the nature of your business, you don't need to. And sometimes you want to, if you have the budget for that and you think that is something you want to expand. But again, these are things that we'll discuss in a one-on-one section, getting to understand more about your business. But this should give you a general guide as to how it works. And I've had clients ask me, what if my business does not fall in any of those classes? That's not possible. In the course of offering my services in this area, I haven't seen one case that doesn't fall under one of those 45 classes. So again, this is what you want to discuss with an expert, and they can find the best class for you. So you're definitely somewhere in the goods or services class. And another thing to note is that protection is with respect to the class that you registered it in. So let's say, for example, I registered my services under class 42, for example. I do not get protection for class 41 or 38. So the protection is dependent on the class that you've registered in. And clients who want multiple protection with respect to different classes that relates to their business, then they want to trademark in those separate classes. If you have a trademark that is a combination of words and logo, interestingly or thankfully, the trademark registry allows you to register a mark as both the word and the logo. So you can do that absolutely. There are times when you want to register just the name, and there are times when you want to register just the logo. Again, you want to consult with an expert because the nature of your business might require that you register just the name, sometimes just the logo, or sometimes the name and the logo together. So for example, if you feel like you're going to change your business logo soon, maybe you're just starting up and you're really just playing with the logo yet, you probably don't want to trademark that at that time. You probably want to stick with trademarking the name which you are more certain of. So again, it depends, but this should just give you an idea of how this works. And again, in the personalized section, we can take a critical look at your business, where you're at, and advise you in a way that it's tailored to your business or your organization. For example, Canto and the Word, this client, we knew that this logo was going to stick with them for a long time. They did not foresee any need for change in the nearest future. And so it was safe to trademark both the name and the logo in one go at the same time. And I've also had a client, for example, that they had a logo and they had a name, but because they were still not quite sure if they were really happy with the logo and were going to change it maybe within the next 2, 3, 4, 5 years, it was best for them to really trademark the name and not attach the logo to it at that time. And that was what we did for them. And, within the year, they actually changed the logo. So you see that it's different for different businesses. If you have a colored logo, we always advise that you trademark in black and white, only because that offers you a wider protection. So if you trademark your mark in the color that it is, let's take Canto and the Word, for example. We're going to be using it a lot here. So Canto and the Word has a purple as their theme, but we did not trademark it as purple because that will mean that they're confined to having it protected in just purple. But we trademark in black and white because that gives you a wider protection. So that's something you bear in mind if you want to trademark your mark. So these are the nuances with respect to trademarking, and that's why this is just one of those, and that's why you really want to consult with an expert to be sure that you're getting the best protection possible. Benefits of trademarking: once you trademark your mark, you have exclusive right to use that mark for a limited time. Exclusive in the sense that it's for you and for you only. And that means that you can exclude other people from using the mark that you have registered in your name. Registration can also be really helpful in cases of infringement, because then you have a prima facie evidence. That just means that you, on the surface, it can be taken that the person with the registered trademark is the true rightful owner of the mark. So it just creates that presumption that it belongs to you. And in cases of infringements, that gives you an advantage, that gives you an edge. Again, it gives you a solid foundation to begin to build your brand, okay? Because the legal protection of your mark is on the one hand, and then actually building the brand itself, which would probably involve getting specialists to help you do that. When protecting your trademark legally gives you the right foundation to then build your brand upon it. Then you know that whatever you're building is on a firm foundation and it's not on a shaky foundation. And that's something that you want to bear in mind, because the cost of actually building a brand, and building in this context means actually putting in the work to build the brand, with respect to the activities you'll be doing, the promotions, and everything that goes into marketing, and just every strategy that helps you actually build your brand. You don't want that to go to waste. You don't want to put in all that effort without having a solid legal foundation for that, because then you may find out that you'd have to rebrand yourself because you might be infringing on an already existing trademark, and you don't want that for your business. You don't want that hassle. You don't want that stress. You don't want that at all. And it's something you can prevent from the start. Financial loss. Besides the financial loss that a brand can experience with respect to other people trying to hijack their brands, they can also have damage to their reputation, because the quality of products that they produce is not what this brand that is claiming to be them, positioning themselves to be them, is going to provide. And because the audience will be mistaken as to who is who, and whether there's a form of relationship between the two companies, or just all of that confusion in the minds of the audience, it's not helpful for them. And so besides the financial loss on the part of the company that has invested time into building their brand, they also get to lose their reputation, because the other brand that is trying to impose as them, that is trying to portray themselves to be them, will offer a less substantial service, and that would really hurt the brand of the brand owner. And as a brand owner, as a trademark owner, besides the financial loss that you'll be getting, if you really do have concern for your audience, you definitely want to protect them as much as possible. So these are the different ways that your brand can benefit from trademark, because it not only protects your brand, it also protects your audience, ensuring that they get exactly what they intend to get by trusting your brand. So you have that level of responsibility, not only to your business, but also to your audience. So really, the audience should not be left wondering, and the brand owner that is taking the time to build their brand should not have to come to wade off these imposters. So the law is trying to help you here. And one way you can accept the help of the law in providing for exclusivity is to have your trademark registered. One way your business can benefit from trademark is to prevent counterfeiting and unfair competition. Now, competition is good. In fact, it's necessary in a democracy, in the market, but it becomes unfair when a new brand takes advantage of the reputation of an existing brand to build their own business. Then if there's a contract between the existing business and the new business, it's a different issue altogether. But to do that without any authorization is just wrong, and trademark can help you prevent that. So let's take, for example, the Dangote that has been around for you know how long. And let's say a new brand of cement comes up and say we are Dangote, maybe adding an additional E to Dangote sound and say we're Dangote. So this kind of it's trying to leverage on the reputation that Dangote would have built over the years. And by the way, this is not a sponsored video in any way. I am not a builder. But assuming that Dangote Cement has, reputation for being high quality product. What is the trademark class and how is it chosen? There's 45 classes of the trademarks under the NICE classification. Don't worry about that. And the way to choose the right class is to go through the 45 classes and select one based on the nature of your business or your organization's activities. Or you can let the trademark expert, once you brief them about your business, let them choose the best class for you, or a combination of these two methods. A trademark application or a trademark registration offers protection in the class under which it is filed. This means that you only enjoy protection for the class under which the trademark application is filed. So if you file under class 42, you're getting protection for class 42 and not class 38 or 39, and vice versa. How do you know the right class? This is where a trademark attorney becomes your best friend. What happens if I don't register my trademark? What happens if you don't register your trademark is that you cannot bring an action of infringement over that mark that you are using. Section 3 of the Trademark Act provides that no person would be able to institute an action for the case of infringement in the case of an unregistered trademark. And this does not mean that you'll be without any form of remedy, honestly. But the closest you have is maybe to bring an action for passing off under the law of tort. But with respect to a case of infringement, it does not apply without having a registered trademark. You don't need a CSC document to register a trademark. And this is where it gets interesting. If you have a company that you want to protect the name as well, then of course you can protect the name as well. But then if you do not have a company, let's say you just working on a brand and it's not yet registered, this means that you can even do a trademark registration before you register your business. That's interesting because, and again, I have to mention that this is a jurisdiction thing. In some other jurisdictions it's a different issue altogether, but with respect to Nigeria, there is no requirement for a CSC certificate to trademark your name. So this also means that if you are a company that has multiple brands, right? So say, for example, you have a company called Gen Z. If you have a company called Gen Z, for example, and you have other different brands under that, you don't need to go for a separate registration. You don't need to register each brand. Say, for example, under Gen Z, you sell Mayo table water. Under Gen Z as a company, you sell Neo's clothing. You know, you don't have to have a company registered for all of these brands on that Gen Z. You could really have Gen Z as a company registered, and you can register all the brands on the Gen Z as trade names. Clients want to know if their trademarks can be revoked after registration, and the answer is yes. There are grounds under which your trademarks can be revoked. For example, if it's expired, the validity period of 7 years is expired and you don't renew it, that could be a ground for revoking the name, because then it has elapsed anyway. And also non-use. If you're not using the mark, the point of trademark is not just to exclude every other person from using your mark when you're not using it. It's to protect you on the grounds that you are using the mark, right? Not that you're just holding or withholding the mark. You have to be using it. And non-use for a continuous period of about 5 years, according to the Trademarks Act, is a ground for revoking your trademark. So you want to be sure that you're using your trademark. And our clients also ask that, oh, do I have to be using it commercially to maintain my mark? And I say it doesn't have to be commercial use. You don't have to commercialize it and monetize it. And of course, you definitely could. And if you're a business, in fact, you should. But they are non-profit, for example, that do not commercialize the use of their trademarks. It's really just to identify and prevent other people from taking on their identity to probably exploit people. So the fact that you're using the mark is sufficient, whether you're using it commercially or non-commercially. The fact that you use the mark is sufficient as use. Okay, we talk about trademark, we go to register trademarks and all of that. Clients also want to know what are the remedies I can have when someone infringes on my trademark, right? Because if there's no benefit, and then it's probably pointless. And this is what I say. There's several options available to you if you find out that your mark is being infringed. You can seek an injunction, which is what will prevent the infringing party. It's an order of the court that prevents the infringing party from using your mark. So the court is going to tell them, hey, stop it. And they'd have no other option than to comply with the order of the court. And another thing you can seek is an account for profit. So someone is infringing your trademark, you can say that, hey, you are trying to unfairly take advantage of my brand that I've built. I need an account for the profit you've made trying to use my name or a name so similar with mine that it confuses my audience. I need an account because I'm going to ask for cost and damages. So this is another remedy that you can have, cost and damages. And we know this is there could be an entire section on this, but it's sufficient for you to know that you can really seek for cost and damages, which is in monetary form. This can get very interesting. To get started with protecting your trademark, there will be a link here. There will be a link somewhere in this video where you can get a checklist for all the things that you'll be needing. And it's not really much. It's really the details of the trademark owner and the details of the business, in case of a business or the organization, and the kind of mark that it is, whether it's a word mark or a logo mark or a combination of word and logo. And so those are the basic information that is required. But then there will be a checklist where you can find everything you need right below this video. And of course, a power of attorney. A power of attorney is just that which, especially if you wanted to consult with us to assist you with the process, a power of attorney is that which empowers us to act on your behalf. It's not something you have to worry about. It's something that we prepare on our end, and we just give it to you to sign to authorize us to act on your behalf. So you don't have to worry about that. Who can apply for a trademark? A person can apply for a trademark, and a person in this context could either be a natural person, which is like you watching this video of me, or a juristic person, which is like a company, a non-profit. So those are juristic persons. So the owner of a trademark could either be a natural person, you may, and in what cases, the cases where a natural person will probably own a trademark is, say for example, as a creative, right? Let's take an actress for example, right? Let's use Omotola, like Nollywood veteran actress, and she really had a name that was almost sexy back in the day. So she could trademark that and own it as herself. So a trademark could be almost sexy. So an individual can own a trademark in that regard. Or even say a solopreneur, for example, and you're running a one-man business, you can have that trademark in your person. You can own the trademark in your person. And juristic persons, non-profit companies, they can have the trademark in themselves as the company and not in the individual, maybe directors or shareholders. No, the company itself can own the trademark. And again, this is another reason why you should consult with an expert with respect to trademark, because they can help you identify the best person to have or to vest the ownership of trademark in, because that's really important. It's the person who has the trademark that can sell out the trademark, that can assign the trademark to someone else. So it's really important who owns the trademark, and sometimes it could get dicey. So you just want to make sure that you have everything right at the outset. Can you assign your trademark? Absolutely, because trademark is an asset. It's an asset that you can monetize, you can commercialize. So yes, you can assign your trademark to someone else, and on an agreement basis, of course. And that is a contract situation that you can negotiate and just ensure that the trademarks registry would just really want to be updated on that transfer. So if you're transferring the trademark, or you're assigning a trademark to someone else, the trademark registry would want to be in the know. And again, you want to speak to your legal person, because then that has got to do with contracts and trademarks, just to be sure that everything is as you intend for it to be. A protection in one class offers you protection in that class only. So if you're filing for protection under, say, class 42, you do not get protected for class 35. And this is something that I feel like even those who know about trademarks do not really know about. So they assume that it's an all-encompassing protection. But I do have a duty to tell you exactly as it is. So if you want protection in multiple classes, then you have to file for protection in those multiple classes. And you do not need a CSA certificate to register your trademark. Isn't that interesting? So let's say, for example, that you have a company that is called Gen Z. It's the closest example that came to mind. And Gen Z as a company, Gen Z Limited, has a lot of other brands. Let's say they sell water, they sell clothing, and they offer payment services as well. So Gen Z as a company can be registered, but they don't need to register their water company and their tech services company and their clothing brand separately. So they could have these as brand names, so they can have Gen Z company and then assume the name of their water is Mayor Water. So they don't need a Mayor Limited. They could trademark Mayor Water. They could trademark, let's say, Neon's clothing. They could trademark, let's say, Gen Payments, right? A CSA certificate is not one of the things that will be required of you upfront, so you don't really need that. If you have that, it's all right. If you're really a business, you should have that, but it's not a necessary requirement to trademark your mark. If you don't register your mark, what happens is that you cannot bring an action for infringement. You cannot say someone else is infringing. The closest thing that you would have is probably passing off under the law of thought, but to bring an action for infringement, the law does not allow you to do that because you don't have a registered trademark. So it's beneficial that you have a registered trademark. Clients want to know upfront how long it takes to register their trademarks, and the first stage is really the search. This is where we look through the register to be sure that your mark is not going to infringe an existing trademark. So it's like having a quick look, like, does this infringe something? Because if you don't go through this phase, if we don't go through this phase, we might end up just having a mark that will already infringe an existing trademark, and we don't want that. And that's why the search stage is very important. And this is the first stage of the application. This is the first stage, the preliminary stage before the application is then filed. Then we file the application on your behalf. At the point of filing, once your application has been submitted to the registry, you get something called an acknowledgement letter. And this is nothing more than we have received your application. It doesn't say we've registered it. It doesn't say we've accepted it. It's only saying we have received your application. So think about it like you work at your office and you receive a mail and you just acknowledge that you've received it. It doesn't mean that you've even taken a look at the content of the mail or have started to work on it. It just says that we've acknowledged receipt of your application. And after, on the average, about 2 weeks, more or less, you get what is called an acceptance letter if your mark is accepted. And an acceptance letter means that we've looked at your mark and it looks good, but we're going to now move it to the next stage. So, and this acceptance letter usually suffices for processes that requires evidence of trademark registration. And this is because the trademark registration itself, obtaining the trademark certificate, takes quite a longer period. And this is why the acceptance letter usually suffices in the interim. So the acceptance letter is saying that it's the trademarks registry saying we've looked at your mark, you've submitted your application, we've taken a look at it, it looks good on our end, but we're still checking on it. And once this is done, it's moved to the publication stage. This is where the trademarks registry would then publish your mark in a journal and call for the public to either oppose it if they have a reason to. And this is the part where if you have a legal person on a retainer, you can really look through this register to be sure that the new names that are about to be approved does not infringe on your name, right? So that's on another hand. But with respect to you now registering, it goes through that facet where anyone who feels like your mark that you're about to register is already infringing their mark, then they can raise an objection to that. But let's not go there in this video. So it suffices to say that after your acknowledgement, you get the acceptance letter, which you can use for other processes in the interim until the publication is out and the statutory period for opposition elapses. And if no one opposes your mark, then you'll be issued the certificate of registration. That takes a longer time, more than a year. So just bear that in mind. So these are the stages of our application that you need to know. How long is your trademark valid for? Nothing lasts forever, and not even your trademark or your trade name. A trademark is first valid for 7 years. So it doesn't last forever. But the good news is that it's renewable. And that means that a trademark owner can actually have perpetual use of that mark. That a trademark owner can actually have perpetual ownership of that mark so long as they continue to renew after 7 years. And this is also where if you have a lawyer on your retainer, they can help you monitor and check on the timelines to ensure that you are not in default, and then you can perpetually own your mark provided you renew as at when due. So a registered trademark can be renewed indefinitely, but at the point of registration, it does not continue indefinitely, but it can be renewed, and you could always renew it and again and again and again and again and again until infinity. Okay, can your trademark application be refused? Yes, it can be refused. So the fact that you've started the procedure for trademarking does not mean that it will automatically be accepted. The trademarks registry has criteria and parameters that they use to decide if a mark should be exclusively granted to someone else. And this is again where speaking to an expert about this can help you, before you even go through all that process, can help you see that your mark is fit and proper for trademark. So it can be refused on grounds that it infringes on an existing trademark. It can be refused on fact that it's deceptive. Let's say, for example, you have a trademark that portrays that you have a relationship with the federal government and you don't, maybe, or that is just deceptive on the surface. Then of course the trademark registry will not allow that mark to be exclusively yours. Again, if it's immoral, if it's not distinctive enough, because again, that's the whole point of trademarks. It's to trademark something that can be exclusively yours. So if it's not distinctive enough, then you will not be able to trademark that, and your application can actually be refused. So say, for example, you want to trademark orange market, and it's in the fruit industry or the food industry. Orange, it's not distinctive. And so most likely the name is going to be refused. And so there are certain names that are typically, a name has to be distinctive for it to have protection. Generic names also will probably not scale through the trademark process, because again, the whole point of trademark is to protect something distinctive exclusively for you. And I know you're probably thinking, how about Apple? You're sure that Apple definitely has a trademark for their mark? Now, there are exceptions to this, and this is one of the exceptions. You can use a generic name where it has nothing to do with your business. So like the example I cited earlier of orange in the fruit market. So if my business has to do with selling food and fruits, I will not have orange. But look at a brand like Apple. Apple has nothing to do with food. And I'm sure that assuming they were a Nigerian company and they wanted to work with Nigerian laws, they will not be able to have Apple if their industry was food and fruit and all of those things. So something like orange, if I said, or if I wanted to trademark orange and it has nothing to do with the fruit or the color, it's just something completely different, then of course in that case it will most definitely pass that test of distinctiveness with respect to the nature of business. I hope this makes sense. Again, you want to speak with an expert and then they can just help you navigate all of this process and then advise you appropriately. Just recently, a client retained our services as a legal practitioner, and I was taking a look at the business and I was looking to see how we can restructure and the best way to put things together legally. So, and I found out that they did not even have a trademark and they've been in business for quite some time. And I'm like, what? And when I brought it to their notice, I realized that they were just not aware. It wasn't like they thought it was expensive or they thought they just didn't want to pay attention to it. So I realized that a lot of people are in this state. They just don't know. If you consider your brand valuable, then you definitely want to take steps to protect it. This video was just to give you some insight on trademarks and the process and the basic things that you need to know about it. If you would like to trademark your brand, you can reach out to me via email and I would see if we need to schedule a consultation section and take it up from there. Again, I am Omolere Abisola, and I'll see you next time.